Good afternoon and welcome back to the Supreme Court of the United Kingdom. We are currently hearing submissions from Mr. Southey, who I will invite to resume his submissions. Mr. Southey.
Thank you, my lord. Can I just, before I go back to where I was, just add something to an answer I gave to my Lord Legate just before the break about the nature of the detachable obligation and the extent to which it sort of relates to the substantive obligation. And my learned friend Ms. Quinlivan very helpfully pointed to the fact that it is important to recognise that, of course, the obligation, the procedural obligation, is detachable not just in the sense of it being a separate obligation, but it doesn't actually necessarily need to be based on a suggested or an alleged breach of Article 2 or Article 3. And if I can just refer the court to, just in support of that, Menson in the United Kingdom, which is in the authorities bundle, it's page 9053, and it was a Strasbourg authority about a racist murder, basically, in 1997. And at 9053, first full paragraph on the page, the European Court made it clear, consistent with other cases, in fact, but made it clear that the fact that there was no alleged Article 2 breach, substantive breach by the state, didn't mean that the procedural obligation had no application. And the procedural obligation arose in part because, of course, it's the procedural obligation that effectively provides deterrence. And so the state was still subject to an obligation under Article 2, despite the fact there was no substantive obligation. So that may shed light on the question I think I was being asked at that point in time. I think my Lord Legate has a question for me.
Well, I was also reflecting on the nature of the obligation over the adjournment study, and you were looking at the Human Rights Act before lunch.
Yes.
But the way I understood Sir James Eadie to be putting it, or at least one way, is that what the court decided in Silly and Janovich was that the obligation is detachable, but also that there's a certain temporal element to the content of the obligation, so that where information arises which a death which gives cause to suspect that a death may have been caused by state agents, it's not every death that you have to investigate, but only a death which has a certain relationship with what they call the critical date, or what has been called the critical date. Now, they said the critical date is the date of when the state concerned gives a right of petition to Strasbourg. But they said that because they were looking at it from their own point of view as the Strasbourg court. If we are asking ourselves what for us is the critical date, as the obligation is transposed into English law, it is the date when our courts acquired jurisdiction to deal with complaints under Article 2 and 3. That's the level of generality at which one should be looking at it. And so the way that works is the content of the obligation is only to investigate dates which have deaths which have the necessary relationship with the date when this court, or these courts in England, acquired jurisdiction over complaints about breaches of Article 2 and 3. That I understood to be the argument. So that's the analysis of the Human Rights Act, which I'd like to hear your answer to, either now or later.
Well, yes, I'm quite happy to deal with it now. My answer to that is this, and it goes back to my basic starting point, which is that one needs to focus on what's in issue, and the fact it's a domestic statutory provision that's in issue. And when one is looking at the nature of the right, for the purposes of the Human Rights Act. Strasbourg sets a temporal limit on that right. It sets it as a matter of international law. It has set it essentially in the case of the United Kingdom as being 1966. But after 1966, Brecknell makes it clear that obligations, fresh obligations, can arise many years after after a death. And my point is that when you then turn to the Human Rights Act, what is the provision that, as a matter of domestic law, limits the jurisdiction of the court? It is Section 22. That is not defined in terms of any provision of the European Convention on Human Rights. It is a simple matter of domestic statute. It bases jurisdiction on there being acts. What is it? What sort of acts essentially engage the convention? It must be acts that Strasbourg would regard as coming within its jurisdiction and that occur after the 2nd of October. And that's the critical point, is that Strasbourg would regard the acts in question, because of Brecknell, as coming within its jurisdiction. Nobody's disputed that. And so if one looks at goes back to Section 22, there is no basis for importing the concept of genuine connection, essentially. And so that's our answer in simple terms. There's either my Lord Sales is.
No, you finish it. I didn't mean to interrupt you, Mr. Southey. I'll come in with.
I mean, our point is there's either an act after the enactment of the Human Rights Act based on Brecknell, or there isn't an act effectively. And once it's accepted that some Brecknell cases relating to deaths before the 2nd of October engage the convention, there's no basis for distinguishing between those acts, because they're all acts that potentially fall within the jurisdiction of the Strasbourg court. Well, sorry.
No, not at all, Mr. Southey. You say it's all about Section 22, but I would have thought that it's wider than that. There's a general principle against retrospectivity of legislation. It's just that Section 22 makes it clear beyond any doubt that Parliament intended that general presumption should apply in relation to the Human Rights Act. Is that not right?
Well, my Lord, I would say it goes a little beyond that, in that Section 22 is how that general presumption is given effect. And Section 22 is effectively what defines the limit of the mirror principle. I mean, the general principle, C. Alsciani, is essentially that so far as possible, people should be able to enforce their rights in domestic courts if they're enforceable in Strasbourg. The exception to that is Section 22. It gives rise to the possibility that somebody may only be able to enforce in Strasbourg, but it's Section 22 that effectively draws the demarcation line.
And could I ask just one other question? Because I was reading McCaughey over the shorter German,
yeah,
and it seemed to me that what Lord Phillips said, but in particular what Lord Brown said at paragraph 100, which is page 4767, I think, was highly germane, where he says there are two principles that one has to bear in mind so far as the Human Rights Act is concerned. One is, yes, there is the mirror principle, which applies to a degree, but the other is the principle against retroactivity, and that in providing an answer to the sort of issue that arose in McCaughey and again arises for us on the arguments today, you have to strike a balance between those two. And if you're doing that, might it not be said that that points towards the relevant analogy being with the critical date for Human Rights Act purposes being the 2nd of October 2000, because otherwise the retroactivity problems do become very considerable, and Parliament might be thought not to have contemplated that they should arise under the Human Rights Act jurisdiction.
Well, there's a number of things I should probably say in response to that. Firstly, we submit that, and this is why I focused on section 22, it's section 22 that strikes that balance, basically. It's section 22, well, balance may be the wrong word, but it's section 22 that marks out the point at which the mirror principle is displaced effectively by the principle of non-retrospectivity. And that's why it's important to focus on the terms, essentially, of section 22. That it is important because my lord effectively was suggesting that it's important to have regard, and it clearly is important to have regard to what Parliament's intent was. But the intent of Parliament, by enacting the Human Rights Act, and this is what Baroness Hale recognised in, I think it's the passage I referred to, I can't remember, I think it may be section 88, not section 88, paragraph 88. But the intention in Parliament implicitly must have been that the Human Rights Act effectively would develop and would potentially give rise to rights being claimed domestically that hadn't been within its contemplation, because the Human Rights Act, the Convention, is a living instrument. And that's why, in one sense, one had the development between McCurr and McCaughey, in that McCurr was decided on the basis that there was no detachable obligation. McCaughey was then decided on the basis that, in fact, the obligation was detachable. And the problem in my submission, it goes back to the point I was making a moment ago, with the problem with Malone, with effectively giving effect to the concept of genuine connection in this context, is that by giving effect to genuine connection, there is a words essentially being read into the act that just aren't there. If there's an act for some Bracknell cases that relate to deaths before the 2nd of October 2000, then there's no reason why there isn't an act for all Bracknell cases that relate to deaths before the 2nd of October 2000.
But I mean, it might be said that the genuine connection test isn't there in the ECHR, but the Strasbourg court has imported it as a condition to the governing the detachability of the investigative obligation so far as the ECHR is concerned. And why isn't the appropriate analogy for us to do the same, following their jurisprudence to that extent, but having regard to the, if you like, constitutional features of our Human Rights Act, which is that it did not have retrospective effect?
Because it goes back to the point I made before, that there is a critical difference in that the Strasbourg court is interpreting effectively the temporal limits of states, of the responsibility of states. Here, one is looking at what in one sense is a narrower issue, which is whether or not you should be able to enforce domestically an obligation that exists on an international plane and is enforceable in the Strasbourg court.
Yes, thank you.
Good. Lord Leggett has a question.
Sorry.
So, as far as I'm concerned, section 22 isn't the problem for you, because as you say, the act is an act of not investigating now when new information has come to light. So that's after the act has come into force. But then, what is the act in question? Well, that takes you back to section 6. It has to be an act which is unlawful and therefore in breach of a convention right. That takes you back to the Article 2, which is the right to an investigation. And if the way that the European Court has analysed that right is not a right to an investigation of every historical death, but only ones which occurred in a certain connection to the critical date, then it's the content of the obligation which has built into it, if you like, a temporal limit. And it's quite maybe significant that the critical date is not the accession to the convention by the state, but the date of petition to Strasbourg, which is when you have the right to bring the case before the court. And it might be a rather odd limit to say that the obligation is linked to the right to bring the case before the court, but that is what they've said. And if we apply that to us, the limit is the distance in time from the right to bring cases to our court.
But my lord, it goes back to the point I was making a moment ago to my Lord Sales, which is that there is a distinction in the sense that what the European Court is saying is that the United Kingdom has no obligations, essentially, save for convention values cases, in relation to deaths that predate 1966, unless there's a genuine connection. So it's about determining the state's obligation. Here, as my learned friend Sir James Eady accepts, one is looking at a situation, one's not looking at the scope of the right, because as a matter of right, Brecknell applies in these cases because they are after 1966.
Well, sorry to interrupt you, but it doesn't, according to Janovich. Brecknell also has, when the information arises afterwards, it has the same limit on the death. And in fact, there's no difference really between a Brecknell case and any other case. Whenever normally information arises which hasn't previously been investigated, that suggests state involvement in a killing, you have to investigate it. But all those obligations have a temporal limit on them, so the European Court says.
Well, my lord, the reason I was saying the genuine connection doesn't apply in a Brecknell case is because these deaths were after 1966. And so from the Strasbourg court's point of view, there's no doubt that there is jurisdiction. And so the right, if we were to go to Strasbourg with these cases, there'd be no problem because of time. The deaths occurred after the death occurred after 1966 in the McQuillan case. The ill treatment, the torture occurred after 1966 in the Hooded Men case. There'd be no problem about retrospectivity. The only question would be whether the Brecknell threshold had been crossed. So in terms of the right exists in Strasbourg, and that's why the problem in my submission, or the issue in my submission, is section 22. It's not about the nature of the right. If in fact the court imposes a restriction in this sort of case, which is to say that right only essentially exists where there's a genuine connection, what the court is doing in those circumstances is adopting a narrower approach to the right than Strasbourg would adopt, because Strasbourg would still accept these cases. Strasbourg wouldn't consider genuine connection at all.
Well, on one view, it isn't, because if you generalize the right, it's a right which it relates to when the court in question acquired jurisdiction. And that's just the same right that's being enforced. It's just that it's a different date when you're in Strasbourg from when you're in England.
Well, but my lord, it's not about the right. The reason why the Strasbourg court, for example, in Silich, adopted its approach was quite clearly because of the fact it didn't want to, or it felt it wasn't appropriate to, or it felt it shouldn't. In fact, as a matter of international law, it held it couldn't. Perhaps is a more important point. Its approach essentially was to conclude that as a matter of international law, there were limits to the extent to which it could bind states in relation to events that occurred before they signed up to the convention, and it referred to the Vienna Convention in relation to that. I mean, an example of that is in Silich, para 140, which is page 5352, and perhaps more extensively in the same judgment, para 106 to 110. (140) is where it refers to Article 28, but then 106 onwards is where it sets out Article 28 of the Vienna Convention.
Well, that's one strand of reasoning, but in Kiyu, this court decided that they had finally settled, at least in Janovitz and other cases on the critical date not being the date of accession, but the date when the right of petition to the court arises, which requires a different analysis, it seems to me.
Well, Strasbourg was quite clearly influenced, though, by the extent to which states were essentially, even if it's about what was enforceable, the extent to which states were effectively bound by things they hadn't signed up to. I'm risking repeating myself, but here we're not concerned with something that the United Kingdom hasn't signed up to. Once the right clearly exists, because my learned friend Sir James Eadie accepts that it would be possible to go to Strasbourg and bring these Brecknell complaints. And so the right, to that extent, whether it starts in 1966 or earlier, is clearly established in these cases. I can see multiple hands now being raised.
If I may butt in before Lord Burrows, if you will forgive me, the right that is established in the Strasbourg court is a right against the state.
Yes.
The right under the Human Rights Act will be against the relevant public authority.
It is.
It is, yes.
Yes.
And Strasbourg has no jurisdiction against the relevant public authority.
Absolutely, but my lord,
my point is simply this: that you're equating the ECHR right with the convention right under the Act, and I'm wondering if you're correct to do so.
Well, my lord, two reasons why in my submission I'm entitled to do that. The first is this. Well, actually, I suppose they're both linked. The reasons that in my submission I'm entitled to do that is this. Section 6, obviously, it imposes liability on public authorities for breaches of rights. How that is defined is by reference to the convention and by reference to convention case law. And that is consistent with the principle in our submission, which is quite clear, which is the mirror principle. And so the basic concept, quite clearly, is that public authorities should be bound by the United Kingdom's international obligations. Now, the restriction on that, it goes back to Section 22, is Section 22, which is in express terms. But Section 22, in our submission, it is focused on this concept of acts, and that's where, say, the detachable nature, the nature of the Brecknell obligation becomes so important, because it means that there are acts after, in particular, the Brecknell threshold has been crossed, or the Brecknell trigger has been crossed.
Lord Burrows.
Yes, just to try and understand in my own words how you're putting it. As I understand it, you're effectively saying there is no retrospective issue actually at all, because we're dealing with a Brecknell detachable obligation that arises after the Human Rights Act comes into place.
Yes.
You're then wanting us to apply the mirror principle, and the important point about that is that that is not a principle that Strasbourg ever has to apply. It is purely a problem for us. And that's why you're able to say that the issues are distinct, seems to me. But as I see it, the problem we have is that it might still be regarded as open to us or required to us to temper the mirror principle by what we might regard on a true interpretation of the Act as retrospective type problems. And if one says, I think your answer will be, no, you've got to apply the mirror principle, full stop, end of it, and that's it. There is no tempering. But as I see it, we have a potential problem with retrospective type problems for which we are seeking an analogous help from the Strasbourg jurisprudence. Now, what is wrong with us tempering the mirror principle by the application of that analogy in order to deal with what appears to be something of a not strictly retrospective problem, but retrospective type problem?
Well, Lord, the answer in my submission is this. Parliament, just to be clear, I'm not saying that the mirror principle does not have its limits, because Section 22 in particular imposes a limit on it, and I accept that. What I'm saying is that what, in my submission for good reason, Lord Roger recognised in Alsciani, is that where the mirror principle is restricted, it is done so essentially by express legislation. It's been limited by, for example, Section 22. And what the court is being invited to do here is not impose interpret an express provision of the statute limiting the mirror principle. It is being asked to effectively import some implied obligation and import an implied restriction in circumstances where essentially the problem that the Secretary of State relies upon is that, or that gives rise to the Secretary of State's submissions, is that the Strasbourg case law, in terms of the nature of the right, has incurred has given rise to the right perhaps having greater consequences than were initially anticipated. But that's nothing unusual. The whole the Human Rights Act, by requiring effectively the interpretation of convention rights to keep pace with Strasbourg, can give rise to rights that are more extensive than initially thought to be the case. And so the way to deal with that is not to import effectively a restriction that's not within the Act. It is to recognise that there are restrictions within the Act, and the two most obvious and the two most relevant are, firstly, the fact that Section 22 imposes restrictions, and then secondly, and I haven't perhaps emphasised this as much, the fact that, of course, you have to be able to be a victim in Strasbourg. And so, for example, if you delay bringing your Brecknell point, you won't be able to bring a Brecknell point domestically because you won't be able to bring it in Strasbourg. Sort of half expect somebody else to raise their hand at that point, but I don't think.
I think you're being allowed now to develop your submissions, Mr. Sully.
Yes. Anyway, where I was just before lunch was, and I will try and cut a couple of things out as a result, was on McCaughey. And the third principle I submitted was clear, which is consistent with the points I've already been making from McCaughey, is that what it was in the minds of the court, and certainly in the minds of the majority of the court, that meant effectively there was no issue of retrospectivity, was the fact that there were acts taking place after the enactment of the Human Rights Act. So, for example, and the relevant passages probably start at electronic 4755. Lord Phillips, when identifying the issue at para 56, made the point that the issue arises because, or the issue that it arises in this case, is that the UK is under an international obligation under the convention because it effectively has held an inquest. That's by just above letter C. And that's then repeated essentially at para 61, or it's perhaps expanded at para 61, where Lord Phillips makes it clear again that the obligation essentially arises because of current events, essentially. by just below letter E, the fourth sentence, I think it is. And his concern at para 62 was that it would be troubling, essentially, if effectively an inquest was going to take place in circumstances where it would had to comply with the convention as a matter of international law, but didn't comply with it domestically. Lord Hope, again, para 65, distinguished between two issues, essentially. One, which was whether or not a procedural obligation could arise, and secondly, what happens if essentially there are steps being taken after commencement. And one sees that the two questions he sets out in para 65 by letter D and E, and what he distinguished essentially between was those two questions. So that in relation to the first of those questions, he held McCurr still held, para 75, but para 76, he held in relation to steps actually being taken, a different approach was required. Baroness Hale, para 89 and 90, no issue of retrospectivity essentially because steps were being taken. Lord Brown, para 101, no issue of retrospectivity because the inquest was still outstanding. Now, all of that in my submission can be translated into this situation for the two reasons that really I identified. Firstly, this is a Brecknell case. What in my submission, the majority that I've just drawn attention to in McCaughey was focusing on was the fact that there were events essentially after the enactment of the Human Rights Act, so there was no issue of retrospectivity. We're in that situation. And of course, in one sense, we go even further in these cases because of the point I made, which is that in both of these cases, PSNI, in fact, have recognised that they need to take action in relation to these cases with a view potentially to leading to criminal proceedings. Now, that was all effectively, we would say, said to reflect the mirror principle. It's fair to say, which links to the point that's been put to me on a number of occasions, really, that Lord Phillips recognised that underlying McCurr essentially was a concern that there might be a limitless obligation essentially imposed on the domestic public authorities, and that's para 61. But of course, we're not arguing for a limitless obligation. We're saying, for example, in the Brecknell case, that an obligation arises at a particular point in time when fresh material, and that is time limited. We accept that there are time limits. Not necessarily the strict 6 months time limits, as Mafalani, I think it's pronounced, 8728, paragraph 76 makes clear. But they are, it is an important restriction. And so in our submission, the approach in McCurr, which was to focus on the fact that an inquest was taking place, is entirely consistent with the analysis, the point I've been making, which is the critical point here is that acts are taking place. And I should point out, although I accept it's a single judge, Lord Phillips recognised the force in that. In the para 63, he recognised that the logic of the position would apply in Brecknell cases. Now, one point I should address is that my learned friend, Sir James Eady, suggested that effectively there had been an incorporation of the concept of critical date into domestic law in McCaughey. Lord Kerr was cited as authority for that. It is, in my submission, not something that is clearly supported by a majority. A majority, in my submission, supports the basic point I've already made, that the critical thing was that steps were taking place after the 2nd of October. Now, that distinction I've just drawn between steps being taken place and steps not taking place, in my submission, is entirely consistent with the analysis of McCaughey by Lord Neuberger in KO. If one goes to KO, page 4558, in particular paragraph 94, Lord Neuberger clearly thought that where, or clearly held, in this respect, he was supported by a majority, that McCaughey effectively decided that where there'd been an inquest, and this was accepted by my learned friend, then the Human Rights Act applied, and he recognised there was no distinction between that and cases where there'd been an inquiry. What he went on to identify essentially as being uncertain was whether or not effectively the Human Rights Act could be relied on in what might be said to be the first category of case identified by Lord Hope, the case where what was being said was that there was a duty that was not being met, effectively no steps were being taken. But that distinction that Lord Neuberger saw as being at the heart of McCaughey is entirely consistent in my submission with my analysis, that the critical point here is what is meant by acts. And indeed, the Secretary of State's statement of case, paragraph 70, is to accept that what was critical in McCaughey was the fact that there was a present day procedure. Now, that obviously, the most recent case is obviously Finucane. Perhaps unsurprisingly, given my learned friend's fair concession, my learned friend James Eadie's fair concession about what was an issue in Finucane, our basic point is that actually, in one sense, Finucane doesn't really deal with the issues that arise in this case, and in particular about the scope of the mirror principle and the extent to which that is constrained by retrospectivity. What in our submission it appears to have occurred in Finucane based on the judgment is that Lord Kerr essentially concluded that the Human Rights Act was potentially engaged through another route, through the route essentially of significant steps being taken after the enactment of the Human Rights Act. That is clear from paragraph 101. He was met by my learned friend Sir James Eadie with an argument essentially that Janowicz imposed or Janowicz led to three issues needing to be decided, or three limitations potentially applying. One of those limitations was said to be the requirement for genuine connection. And what Lord Kerr ultimately concluded was that even if, well, me paraphrasing, but in my submission legitimately paraphrasing, even if that restriction applies, it didn't cause a problem because there was a genuine connection. What it wasn't seeking to do, because it doesn't appear to be in the subject of argument, was address the issue of how genuine connection fits in, if it does fit in, and obviously our cases it doesn't fit in, how it fits into the Human Rights Act. I mean, the high point might be that effectively the last sentence of paragraph 111, where it's a plain and inescapable fact, is that the court in McCaughey unequivocally adopted the decision in Scylla as indicating the principal approach in domestic law to the question of genuine connection. That, though, taking that at its highest, and it's unclear to what extent that was the subject of argument, but taking that at its highest doesn't really address the issue which is raised in this case, which is when does the genuine connection actually apply? And as I say, our basic point in relation to this is that it's difficult to see how the genuine connection applies, because it is essentially a constraint on the mirror principle that is not reflected in the primary legislation. Now, with that in mind, essentially, we submit that the principled approach is as follows. Firstly, ultimately, what any court is doing when deciding whether the Human Rights Act applies is interpreting the Act itself, and is interpreting it in circumstances where the key objective, as recognised in both McCaughey and Alsciani, is the mirror principle. But the mirror principle has been constrained, but it's been constrained by Section 22. When considering that, it is appropriate, indeed necessary, because of the terms of Section 2, to interpret the Article 2 right, taking account of the Strasbourg case law. In particular, as a result, it's appropriate to take account, indeed necessary, to take account of the fact that the duty is separable and detachable. In a Brecknell case, again, because of Section 2, one needs to take account of the fact that the Brecknell case essentially arises from a point, or the Brecknell obligation rather, can arise from a point of time many years after the ill treatment or breach of Article 3 alleged, circumstances where there's no time limit. But because it arises from that point in time, effectively, there is no issue of retrospectivity, assuming that the incident occurs after 1966. The legislation in particular gives no basis, or provides no basis for distinguishing between Brecknell cases where there might be said to be a genuine connection and ones where there isn't necessarily a genuine connection. In cases like this, there is a second reason, arguably, why the Human Rights Act potentially applies, which is that essentially steps are being taken to comply with the convention. I should make it clear, given my Lord Legate's position on the panel, that is not the bootstraps argument that my Lord referred to, because we accept it has to be circumstances where the steps are being taken to comply with the convention. So in this case, we're relying on the fact that steps are being taken to seek to establish criminal liability. In those circumstances, as I say, the critical point here is because of fresh material, in the McQuillan case and in the hooded men case, assuming the Brecknell threshold is crossed in the hooded men case, these are cases that come within the ECHR's, the European Court's temporal jurisdiction. They are cases which my learned friend fairly accepts could be brought in Strasbourg. So the state is responsible for complying with those obligations. And because it's a fresh obligation, to use the language of the European Court of Human Rights, there is no issue as to retrospectivity. I should say that even if we're wrong about that, of course, one feature that I haven't been to of the Finucane judgment that is perhaps of some importance is that Lord Kerr, in that case, made it clear, essentially, that the 10-year time limit, to use his language, and this is paragraph 109, electronic 4712, the 10-year time limit was not necessarily inflexible. And even if I'm wrong, effectively, about my primary position, the weight essentially to be given to the mirror principle, if there is a need for some form of balance to be struck between the interests of the state or the interests of public authorities and the interests of the individual, is not necessarily the same. And so if there is some implicit obligation essentially to restrict the potential application of the mirror principle, it doesn't necessarily need to be applied in exactly the same way as Strasbourg applies it. That's a point in our submission recognised by Lord Kerr in Finucane, was also to some extent recognised by him in Cave, albeit then in a judgment he alone delivered. And that suggests that the approach of the Court of Appeal in our submission is entirely legitimate, which was to look at the factors essentially that pointed towards there needing to be an investigation and hold that they were sufficient and give weight effectively to the fact that this was a right that would be enforceable in Strasbourg. My Lord, I see my Lord Hamlin has a question for me.
Yes, while we're on the Court of Appeal, Mr. Southey, to what extent did your arguments on the mirror principle in section 22 and the critical date feature before then?
Well, my Lord, the answer is, from memory, quite a lot, in the sense that of course, that was pre-Finucane. And so we argued effectively before the Court of Appeal, and I'm not sure, I hope this isn't inappropriate to say it, and we seem to get quite a warm hearing, in fact, that because this was a new obligation, effectively, there was no issue of retrospectivity. What happened after that argument was that Finucane came out, and clearly the judgment needed to take account of Finucane, but there was no argument at that stage about the impact of Finucane. It was the court dealt with it itself on the basis of what the judgment meant. I hope that's a fair, others who were there maybe can disagree with my memory if they wish, but my Lords, unless there's anything else my Lords wish me to address about the Human Rights Act, conscious also of how long I've spent on that, I probably then need to go to the issue of whether the Brecknell threshold was crossed in the context of the hooded men. An issue that is obviously of some importance, given the way in which I've just put the arguments. That is obviously not an issue that arises in McQuillan because of the agreed concession, and so I will say nothing about the the threshold being crossed in McQuillan. Start looking at the threshold and the legal test, though. It is important in my submission to understand that test, both because it's relevant essentially to the approach the Court of Appeal adopted, but it's also relevant to the extent to which one can rely on, or the extent to which the revision judgment was in fact relevant, and whether or not it provided a good reason for departing from the findings of Mr. Justice Maguire, because Mr. Justice Maguire in fact had found that the Brecknell threshold had been crossed. The relevant passages of Brecknell start at electronic 4829 and start again at para 65, passage I already took the court to, which makes it clear, obviously, as I've already indicated, the purpose of the obligation essentially is to prevent the appearance of collusion or tolerance. One thing perhaps I should emphasise, for the just so as to avoid the need to go back to Brecknell for a third time, when looking at independence, is of course what one sees there, which is reflected in other case law, is the importance that Strasbourg attaches essentially to the appearance of collusion or tolerance, and that, in my submission, makes sense, because if ultimately, see for example Menson, the nature of the obligation imposed by the nature of the procedural obligation is that it exists essentially to prevent a sense of impunity. Appearance matters because it's that deterrent effect that the court is essentially emphasizing in relation to the procedural obligations. What Strasbourg then indicated was that because of that public interest at para 69, it was important essentially, or one couldn't be overly prescriptive. I emphasize that because there is a danger in my submission in reading para 71 essentially as being some sort of statutory test. That is clearly not what Strasbourg intended. Indeed, it's not what Strasbourg has subsequently done. Strasbourg then, consistent with that sort of concern about being overly prescriptive, in para 70, made it clear that although there had to be some sort of trigger, you couldn't just trigger an obligation on the basis of any assertion, to use the language of Strasbourg. The approach of the court had to reflect effectively the importance essentially of the public interest in holding people to account, and that's what para 70 in my submission is concerned with, and that's all the context then of para 71, and it explains why in fact the language of para 71 is in our submission a language that actually suggests not that higher threshold, because it talks about the material needing merely to be plausible. It refers to it not necessarily needing to be evidence. It talks about it potentially being an allegation. But there are two important constraints, and that's why. One is it has to be relevant to the punishment or identification of the perpetrators. And secondly, the second constraint essentially is that, of course, what the nature of that obligation is will depend on what the material is. So it's not necessarily saying you have a sort of full-out investigation, whatever that might mean, in all circumstances just because there's an allegation. But it does recognise that the state needs to respond effectively to plausible allegations. Now, one qualification I should put on that point about the standards of the investigation is that it is clear that in terms of independence, although, for example, some of the obligations may be qualified because of the nature of sort of Brecknell obligation, independence remains essentially unchanged, and one sees that at para 72. Now that obligation about that argument about not being too prescriptive is consistent with Hackett, page 4864, where the European Court referred to a new obligation, and this is your reference. It's the last full paragraph on the page, about 3/4 of the way down. It referred to potentially new obligations arising where later events might cast doubt on the effectiveness of the original investigation. And I won't take you, well, page 8542. Göteken, paragraph 21, where the court referred to new developments such as new obligations, for example, because of newly discovered evidence. So what in my submission the European Court does is it recognises, because of the importance of essentially preventing impunity, it recognises the importance of there being flexibility, but recognises in particular that the new obligations can arise where fresh material comes to light, particularly though fresh material that is focused on the identification of those responsible. And that last point we would submit is particularly important in the context of the hooded men, because we submit that is precisely what the new material relates to. That submission in our submission about the threshold is consistent with two judgments of Lord Kerr.
So can I just ask one question about the scope of the Brecknell obligation based on the paragraph 71 that we were looking at, which talks about the eventual prosecution or punishment of the perpetrator on 4831. Can such an obligation arise where the alleged perpetrator couldn't be prosecuted because he's dead?
Well, I would say potentially, because it's it does recognise identification essentially. Because
but that's with a view to prosecution, I read it, and punishment.
Well, my lord, there is a potential value we would submit to identification, because the court has recognised essentially, and if I remember rightly, Menson in fact may make reference to this. The court has recognised that effectively accountability is important. But my lord, in any event, it may not matter on the facts of this case, because at least one of the ministers who is sort of identified in papers is still alive. And more importantly, in some senses, until you investigate, you don't necessarily know who is responsible for who else is responsible. So it's very difficult to say, even in a case like the hooded men, that the people are no longer potentially prosecutable.
Mr. Southey, I can see the force of the latter point.
Yeah.
But is there a case law available from Strasbourg which applies Brecknell to circumstances where the perpetrators have passed away?
I will ask my learned juniors, both of them, to have a look, but I have to say, as far as I'm aware, the answer is no.
Thank you.
As far as I'm aware, it just hasn't been considered, and I should make it clear, not that it's...
I think either in Bracknell or maybe one of the other cases, they say that historical truth is not the object of the exercise.
I absolutely accept that, my lord, and I accept there is a distinction, and that's why the point I made about the bootstraps argument. I accept that there is a limit. I think my Lord Sales has a question for me.
Yeah, or just before we leave this point about the extent to which matters must be pursued, I rather read paragraphs 70 with 71 of Bracknell as indicating that, in effect, this is a form of positive obligation where the investigative obligation revives, and that in examining the extent of it, you have to have regard to looking at the end of paragraph 70, the difficulties involved in policing modern societies, choices to be made in terms of priorities and resources, and so on. So you take that into account in examining the extent of the obligation. And then in paragraph 71, in the middle, the court underlines that in light of the primary purpose of renewed investigative efforts, which in effect I think is a reference back to what is identified in paragraph 65, the authorities are entitled to take into account the prospects of success of any prosecution. So, I mean, broadly speaking, if you've got a police authority which has a choice between policing riots now or pursuing an investigation in relation to someone who's dead, it might well be within their margin of appreciation to give priority to other policing objectives. Is that not a fair way of reading that?
My Lord, I would read it slightly differently. I'd read it in this way. Para 70, in my submission, is concerned with recognising that the trigger has to strike a balance, in the sense that there's a public interest in preventing impunity, but at the same time, you can't impose a burden essentially that arises whenever there is a fresh investigative obligation. That is then, and so para 70 is setting out effectively the things that are relevant to the trigger, and it's identifying factors that need to be taken into account. That's reflected in the first 3 words, or first 5 words of para 71, where the court is talking about with those considerations in mind, which is when it's looking at the trigger. It then goes on to look from the middle of 71 into 72 about the obligations that arise. And what it does in relation to 72 in particular, is recognise effectively that the obligations have to be influenced by, among other things, passage of time, in particular the passage of time. So it recognises, for example, that you may not be able to sort of carry out, looking for the reference, yes, it's at the bottom of the last line in para 72. It recognises that, for example, in terms of promptness, you can't any longer secure the scene, the scene of crime, effectively.
Yes, I mean, the reasons I raised the point is that if you look at the footnote references, footnotes 19 and 21, they're both to the Osmond case, which obviously is the lead authority on the general obligations of policing in society. Ooh, I see Lord Hamlin's, oh, he's back. So they seem to be drawing on the court's general case law already established in Osmond about difficult policing choices in society, and using that to inform both the extent of the obligation as at the trigger stage in paragraph 70, but also the extent of what needs to be done thereafter if the trigger is crossed in paragraph 71. I just wondered if you had a comment on that.
Well, my lord, as I say, I'm not. My disagreement is not with the idea that effectively some of the concerns in Osman aren't relevant. It's to where they're relevant. And in my submission, the way the court took account of that was when it was setting the threshold in para 71. That threshold is meant to represent a balance between effectively an obligation to investigate everything that may come through the door and an obligation that's too narrow because it allows for impunity. And in that context of setting the balance, which is what essentially what the first sentence of para 71 does, it's at that stage that effectively it's taken into account.
Yes, thank you.
I had a feeling somebody else had raised their hand, but I'm not seeing anybody, so I'll carry on. I think one thing, just to be clear, because I'm getting important messages, just to re-emphasize in one sense a point I made before about the facts of these cases. The question was asked of me, what happened if people had died? Of course, although some of the Brecknell material is particularly relevant to identification of ministers, as has been made clear, I think, to me by everybody sitting behind me and sitting in Belfast, is that, of course, in something like the Hooded Men, where you have such a significant incident, there are a large number of potential suspects, and I think we've just lost someone. Oh, sorry,
Lord Sales, we disappeared for a second.
I'm sorry. I think it was an intermittent problem at my end, but I'm back. I heard everything.
Thank you, my lord. All I was saying was that in something like the Hooded Men, of course, there is a large pool of potential suspects. And in those circumstances, in our submission, there's absolutely no basis for assuming that prosecutions are not practical. I was going to refer to two judgments of Lord Kerr on the threshold. The first is at electronic page 460, which is KU.
So I wonder, before you go, just to pursue that last point, but the significance of the Bracknell material was the identification of ministerial involvement and in part the naming of names. But it will be known throughout, would it not, that there would have been officials involved at a fairly senior level in the devising and implementation of this unfortunate strategy.
Well, the critical difference, obviously, and this we would submit is consistent with what Strasbourg found in the revision judgment, is that we now know that there are records that do suggest responsibility for that decision making, and so that there are records that would allow for investigation of responsibility, and in particular, they show the role that both ministers and others potentially played in that decision making. The revision, I mean, in simple terms, I'll come back to this. In simple terms, the revision judgment recognised that had never been addressed, albeit it also recognised that it was clear it had never been addressed in one sense. Perhaps slightly paraphrasing and slightly oversimplifying the position.
Good.
KU Lord Kerr 265, and I accept Lord Kerr in one sense was in a minority in relation to this and in terms of the conclusions he reached, but the comments he makes at 265 in our submission are not inconsistent with the majority and are not inconsistent with what then follows in Finucane. But more importantly, Lord Kerr then makes the point of para 265 that I've just made about the nature of the threshold. But then in Finucane, Lord Kerr considered in much greater depth in our submission the Brecknell trigger at it's electronic page 4713. About the Brecknell trigger, and in particular, he made 3 points in one sense, or 4 points that indicate again the nature of the threshold. Firstly, at para 115, he emphasised sort of passage I emphasised, but then more importantly, he then disagreed essentially with Lord Justice Gillen and the approach Lord Justice Gillen identified. Firstly, at para 117, he disagreed with him on the basis that Lord Gillen had essentially set the threshold too high by saying the material didn't assist because it might not have availed further criminal investigations. And he held that was too high. What was an issue was whether it had the potential to further criminal investigations, potential to undermine rather the conclusions of earlier criminal investigations. Then at para 120, Lord Kerr had noted essentially that Lord Justice Gillen had based his conclusions on a finding of PS&I, that the new material didn't provide any basis for investigation or prosecution. In that context, he was critical, and this may go to the questions I was just being asked to some extent. He was critical of para 125, or of the, not critical, that's the wrong word, but he regarded it as relevant, that the police had focused on the opportunity for further prosecutions. And at para 131, he identified the idea. He identified the importance, he identified the importance of identifying those responsible and exposing them. And that's, in fact, I think the passage I was thinking about when I indicated that the objective may go further than simple criminal prosecution. And that led to him rejecting essentially Lord Justice Gillen's reliance on PS&I's findings, in part because his conclusion at para 135 was that further inconclusive investigation should be pursued further. And his final sort of disagreement with Lord Justice Gillen, or conclusion regarding Lord Justice Gillen's reasoning, is para 136 and 137, where he effectively said that Lord Justice Gillen had erred by reaching a conclusion essentially that it was not possible to make any meaningful assessment of the value of the new material. His view was that one shouldn't speculate essentially about the value of the new material. And that last point is important in our submission when looking at the sort of material one has here. It is quite clear, indeed it's been accepted by those involved, the appellants in this case, that there is potentially further material. There is a lot of material in public records, some of which is public, some of which is not. Nobody has suggested, for good reason, that there is not potentially further material that could be located. And that's in part the context in which one should view the material that has come to light so far. It is, the question in our submission primarily is, does that suggest a need for further investigation because it potentially points to criminal liability? in our submission it does. Can one reach conclusions because the full material's been identified? No, one can't reach conclusions on the basis of full material, but that's precisely, in one sense, why the investigative obligation is so important. Now, obviously, that argument that the Brecknell threshold had been crossed was accepted at first instance by Mr. Justice McGuire. And our submission is that Mr. Justice McGuire was entitled to reach that conclusion. It's paragraph 261-262, electronic 2002. There was, in our submission, no basis for departing from that finding. And so the approach of the Court of Appeal should be set aside. Or the judgment of the Court of Appeal, or the findings of the Court of Appeal should be set aside. But in light of the findings of the Court of Appeal, I think I probably do need to spend a little bit of time on the evidence. Obviously, what's largely prompted this litigation was the Rees memo. But I should immediately say, in our submission, one has to be a bit cautious about simply focusing on the Rees memo, because subsequently further documentation has come to light that we would submit is entirely consistent with what we say is demonstrated by the Rees memo. The Rees memo is at electronic page 333. And although, and I suspect, well, I think my learned friend Ms. Quinlivan will say more about this, although obviously we do submit that what occurred was torture, the critical point about that memo is it is saying effectively that you can't prosecute because a political decision was made. The key words probably are political decision. It is making it clear that it was a decision at a political level, and that clearly obviously generally means ministerial level. And it allocates responsibility to Lord Carrington in particular. Now, the MOD response is at page 3339, which I think was put to one of my learned friends, focuses on two things. One of those things, which is the point that was put, is it seems to focus on the use of the word torture. But secondly, it also focuses on what was published. The reference made is to published records. That, in some senses, is important because Mr. Rees had referred, for example, to talking to his view being confirmed by Brian Faulkner. So he's talking about their material that isn't necessarily confirmed, or isn't in the public domain necessarily, rather. And what the MOD memo does, I wasn't actually going to bring it up, but I think it probably is important. So it's, as I say, at 3339. It refers in particular, for example, to the statements made in Parliament, to what was said in the Parker report, to the European Commission. And so it was referring to public records, not in fact what the court has, which goes beyond public records. The Rees memo, Rees then obviously, although there was then a subsequent email from Mr. Rees, which is at 3343. And what that indicates in our submission is, again, the issue that was being raised essentially was the use of the word torture. So what Mr. Rees essentially says in his second memo is that it would have been better if he referred to the use of interrogation in depth. But he's not suggesting that the basic point he was making, which is that there couldn't be prosecutions for the use of the 5 techniques because that had been authorized, was wrong. And of course, what's critically an issue was who authorized the 5 techniques. Now, that interpretation of the memo, of the correspondence, should be viewed in light of the material that's come to light, the additional material that's come to light. And we highlight some examples of that. And perhaps the first of those examples, which was a document, again, that Mr. Justice McGuire regarded as highly relevant, is a memo at page 2278 electronically. Which is, I think, described by Mr. Justice McGuire as being it's a little unclear on the face of it, but it was described by Mr. Justice McGuire, and I assume this must be right, as being a memo from an MOD official, Mr. Hockaday. And I'm afraid this is one that is not brilliantly well copied. I'm not sure we have a better copy of that. But the critical point about that memo, which is why it's so important potentially, is it identifies essentially the decision-making process, and in particular makes it clear that the Secretary of State had received a note on the 9th of August, which was said to explain what is said to be the supporting methods, which was said to include isolation, fatigue, white sound, deprivation of sense. He then discussed that with the Home Secretary, so that before they both essentially agreed. And that was then followed by Mr. Faulkner, who was then Home Affairs Secretary, Home Affairs Minister rather. It was then led to Mr. Faulkner being briefed. So one sees there a decision-making process which involves apparently details of the techniques being explained to ministers. One reason why that's not terribly surprising is it becomes clear from other documents that the RUC sought assurances at this stage. And of course, assurances were only of value if the decision maker offering an assurance understood what they were being asked to approve. There's another, I won't take you to it, 2288 is another memo, a note in similar terms, recording again this decision-making process of Secretary of State for Defence, Home Secretary, discussing the matter essentially before it goes to Mr. Faulkner. We don't know, as far as I'm aware, what the memo itself that's referred to said. It seems it was probably similar, and it may be the same, as a memo prepared by an officer called Brigadier Lewis on the 9th of August. And that memo is at 2206. I mean, the reason I add a sort of note of that has been transcribed, and the reason I add a note of caution about it is because there's no cross-referencing, so it's difficult to be certain it's that memo. But certainly Mr. Justice McGuire, paragraph 148 of his judgment, thought it must have been in similar terms. And again, what that memo does at paragraph 2 is set out a degree of detail, essentially, about the techniques to be applied. And of course, all of this needs to be viewed in light of the point I've already made, which is the Crown solicitors have accepted, won't take you to it, it's a letter from the 12th of May 2016, so page 3760. Crown solicitors have accepted that there's a considerable volume of material that hasn't been disclosed. Now, I've made reference to assurances. The evidence of assurances essentially is at 3405. At least one example of that is at 3405, where there is a letter there to Treasury solicitor making it clear that these techniques were only embarked upon essentially after assurances were given at high ministerial level. Emphasise the words there, though, in London and Belfast, making it clear that this is not simply Mr. Faulkner. That is reflected also in a minute of a meeting that apparently took place during the course of the Compton investigation, which is at 2504. Where among those present, indeed the first person on the list of attendees was somebody described as Mr. Johnson, who is said to be ACC SB, which one would assume may well be Assistant Chief Constable Special Branch. And if one goes to 2503, the relevant paragraph is paragraph 2, where Mr. Johnson is setting out his concerns about the Compton inquiry. And how, in particular, at 2504, he made it clear that it was only at the last minute, essentially, that the RUC had decided to go ahead with the five techniques after assurances had been given from obtained from the highest places, and the assurances essentially were to give every support short of what was described as physical brutality. Physical brutality was said to be limited essentially to cases where there was bodily contact. So one sees again what that is important in our submission, because those assurances were clearly critical to the operation, but they would have been pretty pointless in our submission had they not been given by someone who understood essentially what was in issue. And that all fits in with this memo, the series of memos describing the approval given on the 9th of August by, in particular, the Home Secretary and the Secretary of State for Defence. One final, sort of in one sense, discrete issue that I should draw attention to is that there is also evidence in the papers, and it does demonstrate to some extent how the picture remains incomplete and how there is plenty of room for further investigation, is that there is a memo at 3402 from the Ministry of Defence that refers to Lord Balneal. It's at the top of 3402, in the last sentence in paragraph 4, refers to Lord Balneal witnessing essentially the techniques of interrogation in September 1971. Now, I would have to accept But in my submission, it doesn't really matter for these purposes, given we're talking about whether there is a need to investigate, that there is some uncertainty about that date. There is some suggestion, not least because of what Lord Balneal said in Parliament, that that might be, in fact, an October date. But in one sense, that doesn't really matter. The question is when that took place in circumstances where, as Mr. Justice Maguire noted in his judgment, this is the easiest place to find it, it's paragraph 10, electronic 1952, two of the men selected for the 5 techniques were selected to have them inflicted on them between the 11th and 18th of October 1971. So if Lord Balneal were aware of the detail of those techniques in September 1971, there's no question, if he witnessed them rather in September 1971, there's no question that he was aware of those techniques while they were still being inflicted. Now, all of that suggests very strongly in our submission that there was specific authority given for behaviour can only be described as criminal at ministerial level. And it was specific authority for the application of the 5 techniques. Now, as Mr. Justice Maguire found in our submission, what occurred subsequently was that although there was recognition that approval had been given for what you've already heard referred to, JIC 6515, there was not admission that ministerial approval had been given for the 5 techniques. And that's important because the memo, I won't take you to it, it's page 3644, the bundle, doesn't describe the techniques. It makes it clear that there can be an atmosphere of rigid discipline and lengthy interrogations, but it doesn't, on the face of it, authorize the 5 techniques. And indeed, it has restrictions, such as, for example, it says that there is a requirement to comply with local law. Now, as Mr. Justice Maguire found, the Compton report simply, and it's para 32, and nobody seriously suggested in the submissions so far that this is wrong, that the Compton report didn't address the issue of responsibility in its conclusions. That's paragraph 32, Mr. Justice Maguire's judgment. Indeed, there is some evidence that what happened in relation to Compton was a deliberate decision was taken not to address responsibility. There is a file note at page 2432. Again, I probably won't take you to it now, given time, where there seems to have been a discussion both about, in fact, whether Compton had disclosed to the other members of his committee all relevant documents, suggesting that the Compton committee didn't have everything, but more importantly, in some senses, suggesting that there was an issue about whether or not the committee could determine who had been responsible. The Compton report was followed by statements in Parliament. Mr. Justice Maguire summarises those at paragraph 14 and makes the point, again, that the response to Compton essentially in Parliament was to say there'd been compliance with, or that decisions had been around the 1965 directive. Lord Balneal, page 2483, in a written answer of the 2nd of December 1971, expressly said ministers had not been acquainted with the detail of the methods. Compton was followed by Parker, which again didn't look at this issue of ministerial responsibility. Now, it's plain that the Parker Committee didn't understand what had been said in Parliament as being an admission of ministerial approval. And the reason I say that is if one goes to the Parker report, page 2525, the majority at paragraph 12 said in terms, second sentence in paragraph 12, it cannot be assumed that any UK minister has ever had the full nature of these particular techniques brought to his attention and authorised their use. Para 8, the minority report, which is at page 2535, second sentence within paragraph 8, the only evidence before us on this point was that it could not be said that UK ministers had ever approved them, meaning the techniques specifically, as opposed to agreeing general principles. And so by the time Parker was published, the understanding of those with a detailed knowledge, really, because that's clearly what the position of the Parker Committee was, of elements of what had happened, were of the opinion that there had been no approval essentially given at ministerial level. And the Compton and Parker committees were not about essentially looking at individual responsibility and criminal responsibility. They weren't, so that, well, they weren't clearly Article 2, Article 3 compliant investigations because they weren't seeking to allocate criminal responsibility. That was then followed, obviously, by the proceedings in the European Court of Human Rights. And as the Commission report makes clear, what happened before the European Court and the European Commission was that the United Kingdom accepted essentially that there was an administrative practice one sees that, for example, at electronic page 3020, and argued that because there'd been administrative practice, that's half, it's the third paragraph of 4 on that page, the first 4 lines, and argued that because of that, it didn't matter, because they'd made that admission effectively, it didn't matter how it had arisen. I mean, the issue was to do, if I understand it and remember correctly, it was to do with effectively the admissibility, whether this was properly a case that could be raised on an interstate level. Indeed, the Irish government complained essentially that there'd been a refusal to identify who had ordered. One sees that at 3080, the last paragraph. Now, in our submission, what the documents demonstrate was that that was a deliberate tactic, essentially, that had been adopted to prevent findings about the role of individual ministers. If one goes to page 3382, one sees there a memo or a note rather, of meeting between the Secretary of State and the Attorney General, where the Attorney General, second paragraph, expressed the view that it would be disastrous if the Irish succeeded in establishing the impression that administrative practices had been condoned at ministerial level, ministerial practices that breached the convention. There was a threat to the reputation of individual former ministers. More generally, what one sees is at 3395, there was a review of these papers conducted before their disclosure. And at the bottom of 3395, when it's looking at whether these papers should be disclosed, it's commented essentially that British ministers at the time had expressed indignation at the implication in the Irish case that they had been personally responsible. However, papers suggested that ministers were aware. Indeed, that seemed to be the sensitivity about these papers. Remember, when looking at that, it's unclear whether whoever wrote this memo reviewing the papers had more papers, the same papers as we do, because the papers we have are not complete. And so one sees every reason to believe that there was essentially a deliberate strategy of not disclosing responsibility for what happened in the course of the European Court of Human Rights litigation. That is also, in our submission, reflected in the approach to the civil litigation. Page 3795 is a memo that's now been obtained essentially regarding the settlement of the civil claim, where at the bottom of that page, at the last full sentence in the long paragraph, it's made clear that effectively part of the reason for settling the claim was to avoid political embarrassment. That's reflected in a series of memos about the civil litigation from 1970, or a series of documents from 1976 about civil litigation. If one goes to 2702, case of Mr. McGuigan, in fact, there was a memo to the Prime Minister about his case. Noted in paragraph 4 the possibility that former ministers might be subpoenaed regarding conspiracy, causing embarrassment, at least is in the document, essentially. That's then followed more specifically in 2709 by a letter to Mary Neve MP from the Secretary of State to Northern Ireland, making it clear that the reason for settling the claims was to avoid embarrassment to those involved at the time, including Lord Carrington. One thing that's worth noting is that that letter seems to have been so sensitive that it prompted the minister who wrote it to then seek to withdraw it. In fact, he did appear to withdraw it or retrieve it from Mr. Neve. One sees that at 2707. Now, all of that demonstrates in our submission that what we know now, sorry, I should say before saying that, all of that, the point I'm making was that there was a desire effectively to seek to prevent information coming to light about who had authorised the deep interrogation, is consistent with findings of Mr. Justice Maguire. He made a finding to that effect at paragraph 49. There's one final thing, actually, before I sort of summarise it, I should actually also draw attention to, is that following the judgment of the European Court of Human Rights, there was a record, or there was a consideration rather, a memo considering to what extent essentially responsibility had been investigated. That is, it starts at electronic 3345. At 3347, paragraph 10, it uses the language of cover up, indicating cover up on the part of the RUC. At paragraph 14, it describes the record essentially of prosecutions as being deplorable. But probably most importantly, at 16 Roman 1, it makes the point it would take, this is what's said by the writer essentially, it would take about a week to discover who was responsible for the authorization of the 5 techniques, but the decision had been made not to do that for policy reasons, not to prosecute for policy reasons. So one sees in my submission a clear course of action adopted, essentially, of deciding not to investigate criminal liability, not in particular to investigate who was responsible for authorizing the 5 techniques. As a consequence, there was no decision, because they had been authorized, there was no action taken against those who'd actually implemented the 5 techniques. But most strikingly, a practice was adopted, essentially, of trying to settle litigation, trying to deal with the European Court of Human Rights in a manner that didn't draw attention to, or didn't result, rather, in findings as to ministerial responsibility. Now, that fact, effectively, that there was a lack of awareness of ministerial responsibility is reflected in the next point in the history, which is something I already touched upon, which is the release of the documents in 2000. And the release of those documents, one sees 3378, essentially, was regarded as sensitive in part because of this point, that there was evidence, essentially, now that of ministerial responsibility that there wasn't awareness of. That all, in our submission, means there's good reason to believe the Brecknell threshold was crossed once this material started coming to light, it started becoming public, because one had, for the first time, material that pointed to individual responsibility, and individual responsibility at a high level. Indeed, that fact it was a high level suggested it was particularly important that action was taken to avoid effectively impunity. Now, the Court of Appeal, that's the basis essentially on which Mr. Justice Maguire found the Brecknell threshold had been crossed. The Court of Appeal revisited that essentially primarily on the basis of the judgment of the European Court of Human Rights in the revision judgment. But what's critical about that is that that was dealing with a different issue. It was dealing with, in particular, whether the new material would have a decisive influence essentially on the previous judgment. And one sees the fact that it's dealing with a new issue from paragraph 79, which is page 5020, where the court assesses and identifies what the issue is. And that's the context in which one should look at the passages dealing in particular with the government papers. My learned friend Sir James didn't take you, it's at page 5027, to paragraphs 114 and 115. He started at paragraph 116. But paragraphs 114 and 115 are important because they're entirely consistent with what I've just submitted, in that they are a recognition that there is now material, essentially, that supports the argument that the 5 techniques were authorized at ministerial level, not only at high level, which is what had been admitted in the European Court of Human Rights judgment. They indicated, as I've already submitted, that there was settlement to avoid embarrassment. Court continued essentially on the same theme at para 115, accepting essentially that the admission of high-level authority had been to avoid detailed inquiry about the ministers involved. But in light of that, it went on to indicate that, that in para 115, that there weren't relevant facts, essentially, that were not known. And that's then the context of paragraph 116 and 117. When one thinks about what was in issue, Ireland was seeking to argue effectively that this was torture. Who had authorized it precisely wasn't necessarily relevant to that. The European Court was clearly aware that there'd been high-level authorization and that there'd been a lack of cooperation by the United Kingdom government, as set out in para 116. It didn't know what this material now suggests, which is that it was in particular authorized at ministerial level, and in particular identifiable ministers were responsible. Difficult to see why that evidence that points to ministerial responsibility was relevant to whether it was torture, but it's clearly relevant to whether or not there is criminal responsibility. And that's what Brecknell is focused on. If you remember the Brecknell threshold, paragraph 71, the Brecknell threshold is concerned with criminal prosecutions. Now, Strasbourg could never have brought a criminal prosecution. It was one of the criticisms. Why Strasbourg, why my learned friend Sir James Eadie was wrong, essentially, to suggest that Strasbourg was part of how there'd been compliance with Article 2. If one looks at the European Court's judgment at page 4927, paragraph 187, the European Court expressly found, in response to a request from the Irish government, essentially, for criminal prosecutions, that it didn't have the power to direct the institution of criminal or disciplinary proceedings. So the European Court firstly couldn't comply with Article 2 or Article 3 because it wasn't concerned with criminal disciplinary proceedings. But secondly, it also, in one sense, didn't matter who the individual responsible was. It wasn't a matter that it had jurisdiction over. And so the revision judgment in our submission, rather than undermining the finding of Mr. Justice Maguire, supports the finding of Mr. Justice Maguire by reaching findings of fact, essentially, that are consistent with the approach of Mr. Justice Maguire. The fact it ultimately concluded that the previous judgment should not be reopened, in our submission, is irrelevant. Returning to the second point made by the Court of Appeal, which essentially was that by 1978, there was a compelling case to investigate. In our submission, that doesn't mean that the Brecknell threshold wasn't crossed. The Brecknell threshold is there because new material can help to identify people and can demonstrate essentially that there is a need to take steps to prevent the appearance of impunity. And this, we would submit, is a classic case of that. Fresh material comes to light, it points to criminal responsibility, and it suggests a way in which that can be investigated, which is by at least starting to conduct a proper review of the contemporaneous documents, because those contemporaneous documents suggest a clear record was taken of responsibility. So in our submission, the Brecknell threshold was clearly crossed in the case of the hooded men. That, I submit, as I say, demonstrates that that threshold was crossed. To the extent that the court concludes that, in fact, the approach of the Court of Appeal to genuine connection in McQuillan was correct, which is obviously not our primary case, and that genuine connection was made out in the McQuillan case, the same logic in our submission would also apply, because of the submissions I've just made, in the hooded men case. This is a Brecknell case. As a result, there would be a right to go to Strasbourg. There is a compelling need, essentially, to investigate in circumstances where there's been no investigation, certainly no criminal investigation, in relation to individual responsibility. And that, applying the approach of the Court of Appeal in McQuillan, would suggest a genuine connection. My Lord, that probably, I think, concludes what I have to say about the application of the Human Rights Act and Brecknell. So it leads independence to be addressed, which coincidentally is the time we reach 4 o'clock. So I'm planning to start on independence tomorrow morning, subject to obviously having an opportunity to discuss that with my team. So there may be 1 or 2 things I come back with in relation to the Human Rights Act, but my plan is to move to independence tomorrow morning.
Well, clearly it's within your discretion to come back and reprise matters that you wish to do so tomorrow morning. But we have at least a roadmap of where you intend to go.
Yes.
Mr. Southey, thank you very much for your submissions. We'll resume again tomorrow morning and the court will now adjourn.